My name is Nathan Hochman, and I'm the Los Angeles County District Attorney. Since taking office on December 3, 2024, among the many cases we have worked on have been the case of People versus Eric and Lyle Menendez. This case, which involved the 1989 brutal murder by the Menendez brothers of their father Jose Menendez and their mother Kitty Menendez, has come back to the courts in May of 2023. Now, this case is on three different tracks. One track involving a habeas petition to get a new trial based on new evidence. A second track involving a petition for clemency directly with the governor of California to get released immediately. And a third track involving a resentencing to get released or put on parole by having the court change their sentence from life without the possibility of parole to life with the possibility of parole. Given the widespread interest in this case by the media and the public, I thought that this case could be a useful portal to understanding how the criminal justice system more generally works. By delving into the anatomy of the Menendez case, we will be able to see how we go from the murder to the investigation to the charges to the trials to the sentencing to the appeals to the present-day petitions and motions. The anatomy of the Menendez case starts with the horrific murders that occurred at around 10 p.m. on August 20th, 1989 in the Menendez's Beverly Hills home. Jose Menendez and his wife Kitty Menendez, while they sat in their den watching TV, were violently shotgunned to death by their own sons. The murderers shot them over 12 times, including a shotgun blast to the back of Jose's head, blast to his kneecaps after he was dead, and a point-blank blast to Kitty's face while she lay on the floor moaning in agony. Officers described the crime scene as one of the most horrific murder scenes they had ever encountered. As soon as the officers arrived, the investigation began. The officers discovered that all the shotgun shells had been picked up by the murderers after the shooting. They spoke with Eric and Lyle Menendez, who had called 911 screaming that someone had shot their parents, and then later claimed to the police and others that the murders were a mafia hit. These investigators followed these leads and others until evidence started to emerge that the killers were the Menendez brothers themselves. At that point, in March of 1990, officers arrested the Menendez brothers for murdering their parents. The district attorney's office reviewed the evidence and decided to file charges against the Menendez brothers for conspiring to murder their parents, for the murder of each of their parents, and special circumstances allegations. Now, the document they filed is a felony complaint. That document itself is not evidence, but it is based on probable cause to believe the Menendezes committed the crimes charged. Once arrested and the charges are filed, the Menendezes are then brought to court where they have a lawyer and the charges are explained. This is the arraignment on those charges. At that point, the Menendez brothers are given a choice. They can plead guilty or not guilty. If they plead guilty, there will be no trial and the next step would be their sentencing. If they plead not guilty, as they did, the decision as to what happens next returns to the district attorney's office. The district attorney can choose to have the case proceed to a preliminary hearing or can present the case to a grand jury for possible indictment. Now, if the case goes to a preliminary hearing, then the district attorney would present evidence to the court to prove the charges by probable cause. At this stage, the prosecution does not have to prove the charges beyond a reasonable doubt like it would have to at a jury trial. A preliminary hearing works as a check in the system to make sure the prosecution has at least probable cause at this point to proceed to a jury trial. At a preliminary hearing, the Menendezes and their lawyers would be present and could cross-examine any witnesses presented by the prosecution. Ultimately, a court determines whether there is probable cause to proceed on the charges. If the district attorney decides not to present the case for a preliminary hearing, it can choose to present the case to a grand jury for possible indictment. A grand jury is made up of people from the community, but it is different than a trial jury in many respects. By law, the grand jury proceedings are not public. The defendants and their lawyers are not present for these proceedings. The prosecution submits evidence to the grand jury, including any evidence that may be favorable to the defendants. Now, the standard used to weigh the evidence is again probable cause, not beyond a reasonable doubt. Ultimately, the grand jury makes a decision of which charges it believes the evidence has shown by probable cause. It returns a true bill or an indictment, or it can vote for a no bill and the indictment is not returned. In this case, the grand jury returned a true bill and charged the Menendez brothers with conspiracy to commit murder, murder for each one of their parents, and special circumstances allegations. Once the grand jury voted to indict, the Menendez brothers were brought back to court with their lawyers for the arraignment on these charges. Once again, they were given the choice to plead guilty or not guilty. In this case, they both pled not guilty to the charges in the indictment. Once the Menendezes pled not guilty to the indictment, one of the challenges they could bring at this point was a legal challenge to the indictment. They brought these legal challenges and other pretrial challenges. The judge considered them and denied the majority of them. Once charges have been filed, the government is obligated to give the defense all of its evidence, proving that the crimes occurred, and also any evidence it may have that is favorable for the defendants. This includes documents, emails, texts, videotapes, audio tapes, witness interviews, and expert reports, just to name a few. The defense has certain reciprocal discovery obligations to the government if it intends to introduce evidence in the defense case at trial. The first Menendez trial occurred from June 1993 to January 1994. The judge determined that there should be separate trials for Eric and Lyle. At each trial, the defendant was presumed innocent, unless and until the government proved its case beyond a reasonable doubt to a unanimous jury. The case proceeded with the opening statements of the lawyers, then the government's case, then the defense case, and then the government's rebuttal case. Once the evidence was all in, each side gave a closing argument. The judge instructed the jury on the relevant law, and they met in secret in the jury room to decide the case. All 12 jurors have to agree unanimously to a verdict on each of the counts, either to find the defendant guilty or not guilty. At trial, a defendant has a Fifth Amendment right under the U.S. Constitution not to incriminate himself. A defendant can elect to testify or not to testify. At the first trial, both Menendezes chose to testify. All 12 jurors have to unanimously agree to a verdict on each of the counts, either to find the defendant guilty or not guilty. If the jury cannot reach a unanimous verdict, this will result in a hung jury and the judge will declare a mistrial. At that point, the prosecution can ask to retry the case and the trial starts over with a new jury. Here the juries were hung, unable to reach verdicts, so the court declared a mistrial and a second jury trial was set. At the second jury trial, which lasted from August 1995 to March of 1996, the government presented its case, and then the defense presented its case for over 2 months. As part of that defense case, the defense presented extensive evidence of the alleged sexual abuse experienced by the Menendez brothers by their father, including over 7 days of testimony by Eric Menendez, as well as the testimony of their cousin Andy Cano. At the second trial, the Menendez brothers again faced the decision of whether to testify. Eric elected to testify, but Lyle did not. After considering all the evidence, the second jury convicted the Menendez brothers of each count of first-degree murder, the conspiracy to commit murder, and each of the special circumstances. At this point, the case moved to the penalty phase, which occurred over almost 3 weeks. The jury was presented with evidence to determine whether the sentence should be the death penalty or life without the possibility of parole. The jury decided to impose a life without the possibility of parole sentence. The Menendez brothers then brought a new trial motion, arguing that the trial judge had made errors in pretrial motions, evidentiary rulings, and jury instructions, as well as there being an insufficient amount of evidence to support the verdicts. The judge considered and rejected each of these arguments. Thereafter, on July 2, 1996, the judge sentenced the Menendez brothers to life without the possibility of parole. The Menendez brothers then challenged their convictions and sentences on direct appeal to the California Court of Appeals, arguing again that the trial judge had made errors in pretrial motions, evidentiary rulings, and jury instructions, and that there was insufficient evidence to support the verdicts. The Court of Appeal heard and rejected these arguments, affirming the convictions and sentences. The Menendezes then appealed and filed a petition for review with the California Supreme Court. That court denied their petition. After striking out on direct appeal, the Menendez brothers then challenged their convictions through a habeas petition directly to the California Supreme Court. In that petition, they allege that their attorneys had provided them legally ineffective assistance of counsel and other constitutional violations. The California Supreme Court rejected that petition. Having not succeeded in their habeas petition to the California Supreme Court, the Menendezes then challenged their convictions in federal court through habeas petitions. They alleged again that the trial court had committed error in pretrial motions, in evidentiary rulings, and on other constitutional grounds. The U.S. District Judge first denied these motions after considering them, and then the Ninth Circuit Court of Appeals heard and rejected these habeas petitions as well. For almost the next 18 years, from September 2005 until May 2023, the Menendezes filed no legal motions. Then starting in May 2023 to the present, the Menendez case has proceeded on three parallel tracks: a habeas petition seeking a new trial based on new evidence, a clemency petition seeking the governor to commute their sentences and release them immediately, and a resentencing motion to obtain a new sentence that will allow for parole. Having failed to succeed on their first habeas petition that the California Supreme Court rejected back in 1999, the Menendezes filed a second California habeas petition. That habeas petition is allegedly based on new evidence. That new evidence has to be timely, it has to be admissible, it has to be material, and it has to be credible. The second track this case is proceeding under is clemency, where the governor has the constitutional power in any criminal case to commute a convicted inmate's sentence and release them immediately. Governor Newsom has had this power since he took office in 2019 and can exercise this power at any point since then, or he can do nothing. There is no court hearing, there is no deadline, and there is no appeal. The third track is resentencing. California is one of the few states where the state legislature has passed a law permitting resentencing. A resentencing motion, which begins the process, can only be filed by certain parties, one of which is the district attorney, and another of which is, under certain circumstances, the court. A convicted inmate cannot file the resentencing motion. A district attorney also has the power to withdraw a request for resentencing if there are legitimate reasons to do so, subject to the court's approval. Unlike a habeas petition, which focuses on the trial itself, a resentencing motion allows the court to focus on rehabilitation and other factors as well. In this case, in late October of 2024, the prior district attorney filed a resentencing motion, and the court also filed its motion for resentencing. If the court were to resentence the Menendez brothers from a life without the possibility of parole sentence to one with the possibility of parole, for instance, a sentence of 50 years to life recommended by the prior district attorney, then the Menendez brothers would qualify for a parole hearing before the parole board. The parole board has the power to recommend to the governor that they be granted parole or that parole be denied. If the parole board, for example, recommends a grant of parole for the Menendez brothers, then it goes to Governor Newsom's desk. He has 120 days to affirm that grant of parole, reverse it, or modify it. As an example of how the system works, Several years ago, the parole board granted parole to Sirhan Sirhan, who assassinated Senator Robert F. Kennedy in Los Angeles in 1968. For 40 years and 15 parole hearings, the parole board had previously denied Sirhan Sirhan parole. However, on the 16th parole hearing in 2021, the parole board granted parole. Despite the fact that Sirhan Sirhan had been in prison for over 50 years, was in his late 70s in diminishing health, Governor Newsom reversed that grant of parole, stating that Sirhan Sirhan had not exhibited sufficient insight into his crime by denying his role in the assassination. As a result, Sirhan Sirhan remains behind bars. I hope this anatomy of the Menendez case has shed light on how the criminal justice system works and the due process protections afforded to a defendant who's been charged with a crime, convicted by a jury, and sentenced by a judge. I strongly encourage anyone who has been interested in this case to use this case as a means to learn more about the criminal justice system and about other cases that are being prosecuted on a daily basis in courts throughout this country.